Welcome. In this presentation, I will introduce you to the General Data Protection Regulation in such a way that you will be able to explain the GDPR in just a few minutes. This could be useful if, for example, you want to promote a basic understanding of GDPR compliance within your organization. As you may have noticed, this video is quite long. If you would prefer a shorter version, simply jump to the marker currently displayed somewhere on the screen. Few EU laws have received as much attention, both popular and global, as the GDPR. While it has drawn much needed attention to the importance of privacy and the protection of personal data, it has also created an unhealthy fear, causing some organizations to fail to realize the full potential of data. In this presentation, I have distilled the 99 articles and 173 recitals of the GDPR into 6 overarching principles of roughly equal importance. The presentation is based on a book chapter that I published in 2021 titled GDPR Compliant Processing of Big Data in Small Business, which I later refined for the book GDPR Compliance. The 6 principles are legitimacy, proportionality, empowerment, transparency, accountability, and security. Privacy plays an important role in both democracy and individual autonomy, and a balance must be struck between solitude and companionship. Both are necessary for the development of democracy and individual agency. The right to privacy, including the protection of personal data, is enshrined in EU law as a fundamental right, that is, law on a treaty level. These rights, therefore, appear alongside other democratic rights and freedoms, such as freedom of thought and expression. Data protection law is a complex subject, not due to the lack of clarity in the applicable provisions, but because a complex balancing of interests is necessary. The right to the protection of personal data is not an absolute right. It must be considered in relation to its function in society and be balanced against other fundamental rights in accordance with the principle of proportionality. The GDPR applies to the processing of personal data. Personal data is information relating to an identified or identifiable natural person, known as the data subject. Personal data relates to the data subject, where the information, by reason of its content, purpose, or effect, is linked to a particular person. Processing covers any operation performed on personal data, including collection, use, disclosure, and deletion. The GDPR must be complied with by the data controller, who is the natural or legal person that determines the purposes and means of processing of personal data, either alone or jointly with others. The territorial scope of the GDPR includes data controllers established in the European Union and the processing of data concerning data subjects in the European Union with a view to offering products or monitoring behavior within the Union, even when the data controller is not established in the European Union. First principle, legitimacy. Personal data may only be processed for legitimate, specified, and explicit purposes. Any data collected must not be processed in a way that is incompatible with the original purposes. Legitimacy can be perceived as the overarching principle that includes the general requirement for fair and lawful processing. When organizations process personal data, they are obliged to ensure that the processing is legitimate. Privacy protection requires that derogations and limitations only apply where strictly necessary, and that exceptions to protection are narrowly construed. Organizations do not own personal data, nor are they entitled to process it by default. However, they are permitted, with limitations and requirements set out in the GDPR, to interfere with citizens' right to privacy, including the protection of personal data. In addition to serving a legitimate purpose, personal data must be processed fairly and be based on a legitimate basis, as we addressed under the next principle, which is proportionality. Second principle, proportionality. Given the myriad ways in which data processing can be carried out, the principle of legitimacy is coupled with the proportionality principle that permeates the GDPR. This is evident in the frequent references to what is necessary, adequate, appropriate, compatible, reasonable, and so on. The legitimacy of processing depends on the nature, scope, context, and purposes of the processing, as well as the risks of varying likelihood and severity to the rights and freedoms of natural persons. The same video surveillance, for example, may be lawful for security reasons, but unlawful for marketing purposes. The rules aim to strike an appropriate balance between protecting the rights of the data subject and the legitimate interests of data controllers, third parties, and the public. According to the general principles set out in Article 5 of the GDPR, personal data should be limited to what is necessary and should not be kept for longer than is necessary. These restrictions are known as data minimization and storage limitation. In this context, necessity is relative to the purposes for which the personal data are being processed, as discussed under the principle of legitimacy. The purpose limitation states that personal data cannot be further processed in a manner that is incompatible with the purposes for which they are collected. This also reflects the proportionality test. According to Article 8 of the Charter of Fundamental Rights of the European Union, the processing of personal data must be based on the data subject's consent or some other legitimate basis laid down by law. The GDPR provides such legitimate basis for processing personal data. These are referred to as legal basis in the GDPR. A legal basis must exist for each purpose for which personal data are processed. The GDPR distinguishes between normal and sensitive personal data. Article 6 of the GDPR sets out the legal basis for processing normal personal data, while Article 9 deals with sensitive personal data. The processing of normal personal data is lawful when the data subject has given consent to the processing, when processing is necessary for the performance of a contract, when processing is necessary for compliance with a legal obligation, when processing is necessary in order to protect the vital interest of the data subject, when processing is necessary for the performance of a task carried out in the public interest, or when processing is necessary for the purposes of the legitimate interests pursued by the controller, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject. This last legal basis is known as the balancing test. Consent requires a freely given, specific, informed, and unambiguous indication of the data subject's wishes, which signifies agreement to the processing of their data. The request for consent must be presented in a manner which is clearly distinguishable from other matters, and consent may be withdrawn at any time. As mentioned, personal data may be processed without consent if it is necessary for the performance of a contract or to comply with a legal obligation. Together, these legal bases justify the processing necessary for businesses to deliver products and comply with tax and accounting obligations without consent from the data subject. Consent should never be sought for such purposes. This becomes clear when you consider the consequences of withdrawing such consent for processing that is in fact necessary, either to perform a contract or to comply with a legal obligation. Processing is also lawful without consent if it passes the balancing test, which is a legal basis that to some extent can justify processing for marketing purposes, for instance. The balancing test, also known as legitimate interest, enables the data controller to process personal data when processing is necessary for legitimate purposes, unless the interests or fundamental rights and freedoms of the data subject override the data controller's interest. In the public sector, personal data may be processed to the extent that it is necessary for carrying out a task in the public interest. The term necessary, which appears in all legal bases except consent, has its own independent meaning in EU law and must be interpreted in a way that reflects the objectives of data protection law as a fundamental right. This cannot be emphasized enough. In other words, processing must be objectively necessary for the intended purpose rather than merely useful. And the risks to the rights and freedoms of natural persons must also be taken into account. As we will discuss under the principle of empowerment, both consent and the balancing test present a disadvantage to businesses in that the data subject can object to processing. In the former case, this is done by withdrawing consent, while in the latter, by exercising the right to object. However, the data subject cannot object if processing is objectively necessary either to perform a contract or to comply with a legal obligation. The processing of sensitive personal data is prohibited. However, there are exceptions, including when explicit consent has been obtained. Sensitive personal data is also known as special categories of personal data and is defined as data falling within the categories listed exhaustively in Article 9 of the GDPR. This list includes personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, data concerning health or sexual orientation. This prohibition also applies to situations where the analysis of normal data is intended to extract sensitive personal data. Proportionality also plays a role in relation to the data controller's general obligations, which will be discussed later under the principle of accountability. When determining the data controller's responsibilities, account must be taken of the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for the rights and freedoms of natural persons. When implementing certain required measures, consideration must also be given to the state of the art and the cost of implementation. As we will discuss under the principle of security, technical and organizational measures must be appropriate. When it comes to the rights to rectification and erasure, which we will address under the principle of empowerment, account must be taken of available technology and the cost of implementation, as well as disproportionate effort. In line with EU legal tradition, the principle of proportionality requires that the processing of personal data must not exceed what is necessary to achieve legitimate objectives. In this context, consideration should also be given to the availability of realistic, less intrusive alternatives to the intended processing. Third principle, empowerment. The concepts of human agency and the right to self-determination are central to legal theory. The principle of empowerment can be understood as giving individuals the power to act in accordance with their own goals, values, and preferences. Despite the principle of empowerment, data subjects do not have absolute control over which of their data is being processed or by whom. Here we focus primarily on the data subject's rights, which are closely linked to the principle of transparency. Consent is one of the clearest examples of empowerment. In addition to being specific and informed, consent must be freely given and constitute an unambiguous indication of the data subject's wishes, signifying agreement to the processing of personal data. Consent requires both transparency and clear affirmative action. Therefore, silence, pre-tick boxes, or inactivity cannot constitute consent. In the context of consent, freely given requires a genuinely free choice. This requirement is not met if the data subject is unable to refuse or withdraw consent without detriment. In addition to situations where consent is required, data subjects are empowered by rights concerning access, rectification, erasure, and objection. They have the right to obtain confirmation as to whether or not their personal data is being processed. If their personal data is being processed, data subjects have the right of access to the personal data, as well as to receive information about the purposes, categories, envisaged storage period, and other information detailed in Article 15 of the GDPR. The right to obtain the rectification of inaccurate personal data is closely linked to the general requirement to ensure the accuracy of personal data. The so-called right to be forgotten means that data subjects can request the deletion of their personal data even when the data is accurate. However, this right is limited to certain grounds, such as when the data is no longer necessary for the intended purpose, or when consent has been withdrawn and there is no other legal ground for processing the data. In order to honor such a request, the data controller may choose to irreversibly anonymize the data, since anonymized data are not personal data and thus fall outside the scope of the GDPR. As mentioned under the principle of proportionality, the data subject has the right to withdraw their consent at any time. If the legal basis for processing is the balancing test, the data subject has the right to object to the processing. The data controller must comply unless they can demonstrate compelling legitimate grounds for the processing that override the interests, rights, and freedoms of the data subject. Other rights include the right to data portability and the right not to be subject to automated individual decision-making, including profiling. The latter is particularly important in the context of decisions that rely on artificial intelligence. Fourth principle, transparency. Transparency is a key feature of EU law. Transparent processing of personal data is essential for accountability towards the relevant authorities and for empowering the data subjects. The principle of transparency is closely linked to both legitimacy and proportionality. It is also an essential component of informed and specific consent. Furthermore, requests for consent must be clearly distinguishable from other matters, such as contractual terms, in order to ensure transparency. Articles 13 and 14 of the GDPR contain comprehensive information requirements to ensure that data subjects are informed of the identity and contact details of the data controller, the purposes of processing personal data, the categories of personal data processed, and the data subject's rights. They also require the provision of any other information that is necessary to ensure fair and transparent processing in respect of the data subject. In the context of automated decision-making, including profiling, transparency requires the provision of meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the data subject. In the context of data protection, this obligation could reasonably be considered the gold standard for transparency. Any information provided to the data subject must be given in writing, including electronically, and must be provided in a concise, transparent, intelligible, and easily accessible form using clear and plain language. Although the GDPR does not require data controllers to publish a privacy policy on their website, Doing so is often an efficient way of informing the data subject, for instance via a hyperlink. The content of such a published privacy policy can be produced alongside the required record of processing activity as discussed under the next principle of accountability. Fifth principle, accountability. The data controller is responsible not only for ensuring compliance, but also for being able to demonstrate compliance. To this end, the data controller must implement appropriate technical and organizational measures to ensure that processing is performed in accordance with the GDPR, and that they can demonstrate this. These measures must be kept up to date, and as discussed before under the principle of proportionality, must take into account the nature, scope, context, and purposes of processing. Risks of varying likelihood and severity to the rights and freedoms of natural persons must also be considered. Implementing these measures must include appropriate data protection policies. If consent is obtained from the data subject, the data controller must be able to demonstrate that consent has been given. One of the most concrete measures of accountability is the requirement to maintain a record of processing activities. While this record must be made available to the supervisory authority upon request, it does not have to be published, for example, as part of a privacy policy. Before processing personal data that is likely to result in a high risk to the rights and freedoms of natural persons, the data controller must conduct a data protection impact assessment of the envisaged processing. This is required in certain cases involving, for instance, systematic and extensive evaluation of personal aspects relating to natural persons based on automated processing, including profiling. If the assessment indicates that the envisaged processing would result in a high risk without measures to mitigate it, the data controller must consult the supervisory authority before processing begins. In certain situations, the data controller is required to appoint a data protection officer, including in cases where the processing is carried out by a public authority or where the core activities consist of processing operations which, by virtue of their nature, scope, and/or purposes, require regular and systematic monitoring of data subjects on a large scale. As discussed earlier, these requirements can also be viewed as examples of proportionality. Compliance is further supported by the requirement for data protection by design and by default. The data controller must implement appropriate technical and organizational measures to ensure compliance, to integrate necessary safeguards, and to ensure that only the necessary personal data are processed by default settings. This provision supports all 6 of the principles presented here. Simply add by design after each one. For example, legitimacy by design, empowerment by design, transparency by design. 6th principle, security. To avoid the risk of personal data being destroyed, altered, disclosed, or accessed improperly or unintentionally, it is of paramount importance to process personal data securely. In many cases, the real threat in the context of processing personal data is not the data controller's exploitation, but rather a lack of security measures, resulting in data breaches and subsequent exploitation by third parties, including employees and subcontractors. Thus, observing data minimization and storage limitation, as well as using anonymization and pseudonymization, is essential for ensuring security. The data controller must implement appropriate technical and organizational measures to ensure a level of security that is appropriate to the risk relating to the rights and freedoms of the data subject. This must take into account the state of the art, the costs of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of varying likelihood and severity for the rights and freedoms of natural persons, as discussed under the principle of proportionality. Security measures may include the pseudonymization and encryption of personal data, the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services, the ability to restore the availability of and access to personal data in a timely manner in the event of a physical or technical incident, and a process for regular testing, assessing, and evaluating the effectiveness of technical and organizational measures for ensuring the security of the processing. The data controller must ensure that any natural person acting under their or a data processor's authority who has access to personal data does not process it without instruction from the data controller. In the event of a personal data breach, the data controller must notify the supervisory authority and data subjects if there is a risk to the rights and freedoms of natural persons. In line with the proportionality principle, data subjects need only be informed if the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons. This figure illustrates the 6 principles. In short, and subject to the principle of proportionality, the data controller must ensure legitimacy, transparency, and security, to demonstrate accountability and ensure empowerment of the data subject. So, to explain the GDPR in a few minutes, we must first emphasize that the right to privacy and the protection of personal data are fundamental democratic rights in the European Union. This means that data controllers must pursue legitimate and explicit purposes in a fair and careful manner in order to lawfully interfere with data subjects' right to privacy. They must also consider the legitimate interests of data subjects, third parties, and the public. In order to comply with the legitimacy principle, data controllers must ensure that they have a legitimate purpose and legal basis for the processing, while also observing requirements such as accuracy, data minimization, and storage limitation. Even when consent has been obtained, the processing of personal data must be genuinely necessary for the intended purpose. The data controller is obliged to ensure transparency by informing the data subject about the processing and the rights afforded to them. Natural persons should be made aware of the risks, rules, safeguards, and their rights in relation to the processing of personal data, as well as how to exercise these rights. Transparency also applies towards the supervisory authorities on request or when prescribed by law, for example in the context of data protection impact assessments. When personal data is entrusted to data controllers, appropriate technical and organizational measures must be in place to prevent its accidental or unlawful destruction, loss, alteration, or unauthorized disclosure or access. The level of security must be appropriate to the risks to the rights and freedoms of the data subject. In this context, observing data minimization and storage limitation can also be considered a security measure. The data controller must be able to demonstrate compliance with the GDPR. This includes maintaining a record of processing activities, carrying out data protection impact assessment, and ensuring data protection by design and by default. The principle of accountability means that the data controller must be able to demonstrate compliance with the principles of legitimacy, transparency, and security. In order to be empowered, data subjects must be informed about the data controller and the processing, and they must understand their rights and the implications of the processing. To a large extent, data subjects are in control of what data concerning them can lawfully be processed, including through consent and the rights of access, rectification, erasure, and objection. Adhering to the principles of legitimacy and transparency empowers the data subject. The protection of personal data, including the obligations of the data controller, is relative to the legitimate purpose being pursued and the impact on privacy. This includes the nature, scope, context, and purposes of processing personal data. According to the proportionality principle, the greater the risk to the rights and freedoms of data subjects, the greater the requirements for the data controller to ensure legitimacy, transparency, and security. This model should help you understand and explain the GDPR in just a few minutes. The 6 principles overlap and essentially amount to a matter of due diligence. For compliance purposes, the 6 principles can be broadly categorized into 3 pairs. Lawful processing, comprising legitimacy and proportionality. The data controller's obligations, comprising accountability and security. And the data subject's rights, comprising empowerment and transparency. Thank you for your interest in the GDPR compliant processing of personal data. This is not the whole story, of course, but rather a compass that can help you navigate the processing of personal data safely and with respect for fundamental human rights.